This is the plaintiff, Thomas Merrick. He says he rented from the defendant, who, if you look up scammer landlord in the dictionary, you'll see a picture of him. He sure does know how to play the system and manipulate the law, all right? He's here to stand up for his rights, put a stop to the defendant's evil ways, and hopes the judge agrees to give him his $350 security deposit back. This is the defendant, Scott Weltmer. He says he owes the plaintiff nothing because he was stood up for the walkthrough and the guy never even called to reschedule. The other tenants moved in on the day the plaintiff moved out, and since no walkthrough ever occurred, he has every right to keep the money. He's accused of getting in over his head.
All parties, please raise your right hands.
And welcome back to the People's Court. Next case on the docket, the plaintiff says he's been manipulated and swindled by his landlord, who won't return his security deposit. But the defendant says the plaintiff made a fatal error, which is going to cost him. It's the case of getting it over his head.
Okay, Thomas Merrick and Tanya Merrick, represented here by Thomas Merrick. You are suing your former landlord, Scott Weltmore and Betty Weltmore. Just the men folk came, right? He'll be representing you and your wife for $350 security deposit that you say he owes you and unlawfully refuses to repay. Tell me what's going on.
On July 13th of 2010, I paid a $350 security deposit and the first month's rent on that day, and I signed a 6-month lease.
You moved into an apartment of his, and on what date?
We moved into his apartment on August 1st of 2010.
Okay, and then when the 6 months were over, you left? Or you
we
stayed
moved out, yes.
Okay, and did you get along well as landlord and tenant? You didn't have to get along.
For the most part, but okay. I mean, it was a business arrangement.
Okay.
Nothing personal that I ever took
So when it was time for you to leave, did he still own the place?
No.
What had happened?
He had deeded over the property to, I believe, the former owners or the people that he purchased it from.
Tell me about that.
Yeah, I've been negotiating with them to avoid foreclosure, and I want to do deed in lieu. My attorney had been communicating with them, and we actually signed the paperwork on January 7th.
Because you had a mortgage with the former owner, you mean?
Yeah, when I purchased it, they had owner financing.
Owner financing. And then it just didn't work out?
Well, I had 13 of them, and I got divorced, and it just was...
Wait, you had 13 properties?
Yes, ma'am.
Okay, and then you got divorced?
And you know it's like in Florida with the rental and the homes. It turned into a disaster.
Well, I also know what it's like when people maybe spread themselves a little thin and have no surplus.
Real thin, that's for sure.
Right. I mean, you're not the only guy who did that. There was a lot of that going on in Florida and elsewhere. But okay, so you hit on some hard times, and then what? In return for him not suing you, you just signed over the deed to him?
Yeah, well, I tried to negotiate. I just wanted to give it back to him, and foreclosure is very expensive.
So did you end up making any money, or you didn't make any money?
No, I lost a substantial amount of money.
All right, so that happens before he exits?
That occurred on Friday the 7th of January.
Okay, and then you move out when?
January 28th.
All right, so when you move out, you call him and you say, hey, we're ready to do a walkthrough. I have a security deposit I want back.
No, at that point, he no longer owned the property. We contacted the new owners via email, and they sent me back an email and said,
we don't have your money.
He didn't turn anything over to him,
right.
And they said in their email that everything looked beautiful. They'd be happy to give the money back.
Okay, if we had the money, we'd be happy to give it back.
If they had it, if it would have been turned over, then they would give it back.
Okay, so you have not returned the $350 security deposit, and why? Right. What is your claim on
actually,
it?
when my attorney wrote the prior owners and the current owners, there's a quote off of here is, their offer is your clients receive the 2 documents, everyone calls it a day, no back rent, no deposits. In parentheses, I don't think Scott has any money. The tenants have the keys, etc. The water bill and insurance are up to date, blah, blah, blah.
Okay, so if a landlord sells the property, does he continue to be responsible to the tenants who were there before he sold the building?
No, it's not his problem anymore. He's completely sold the building. It's the new guy's problem. It's not his problem.
Is that right? It's the new guy's problem only?
Yes, that is.
Because?
He's no longer the owner.
He can just wash his hands of the whole thing.
Yes, I would.
Well, of course you would if you were the landlord. Duh, going inside the courtroom.
The prior owners accepted this offer in that writing, and it was recorded that way through my attorney. And my attorney, when I talked to him, he said, they need to go after the new owners. He said, you signed this, and that's
Okay, you're either your attorney, that's not the full story about what your attorney told you, or your attorney's mistaken. Because here's the deal. He can choose to go after either of you. Really, it's up to him to choose who he wants to go. He could go after the new owners / old owners and say, hey, listen, this obligation runs with the land and you have to pay me. He didn't choose to do that. What he chose to do instead is go after you because he put the money in your pocket.
Correct.
And so he is going after you and he wants his $350 back. So do you have a legal reason why you're not giving it back to him?
My legal reason was that the new owners accepted this contract. It was a legally binding contract.
You may have, I don't know, you speak to your lawyer about that, but maybe you want to sue them for the $350 and claim that by accepting this, they weren't just waiving a right to sue you for all the back money that you owed, but also indemnifying you from your legal obligations to him. That's going to be a tough stretch, but that's not my concern. He gave you $350. What reason do you have? In your answer to the complaint, you say, well, he didn't show up for a walkthrough.
Well, he also didn't. I was supposed to walk through on Sunday. They moved out on Saturday. I went over there, and there was no one there, and the tenants downstairs told me they gave the keys to the new owners. And then I just talked to my attorney, and he told me, said the new owners accepted.
Why isn't your attorney here to help you?
I don't need him.
He wouldn't do you much good. I can tell you that much. All right. First of all, you have no right to it. But second of all, even if you did, you'd have a problem. And I know that did you lose all your properties?
Well, they're all in some stage of foreclosure except my primary residence.
Okay. Understand that, like many states, Florida has laws about what landlords must do and the timing and everything else. I cannot imagine that your lawyer did not tell you about this. What a landlord has to do is you have to return a security deposit within 15 days or within 30. If you haven't returned the security deposit, you must send a letter, certified mail, explaining what grounds you have to keep it. If you do not do that, you automatically forfeit the right to litigate this and lay claim on the security deposit. If a guy did $10,000 worth of damage, you can come later and sue and make your own lawsuit against him for $10,000 in damage, but you got to return the security deposit. That's where we are. So you got to return the security deposit. $350, verdict for the plaintiff.
Well, so that was plain and simple right there. I mean, the law is the law. Step in. You got that on the ruling, right? You understand the law.
Yes, sir.
And what your responsibility is under the law.
Well, I understand that the new owners agreed to those terms, and so I believe that's what they agreed to. They signed it. It was recorded. The deed was recorded. So my attorney told me, so that's what I'm going with.
All right. So keeping the security, though, as a landlord, you had to write that letter within 30 days.
Right.
To keep it.
Correct.
And
I mean, I might have took a misstep there. I never did a walkthrough, so that's how I feel about it.
Yeah, but you didn't write the letter. That's what the law.
Right. I obviously made a misstep on that.
Right. All right. Head right down there. All right. So he's out of the real estate business. And what's your feeling on the outcome here? How'd you like him as a landlord?
It was all right. It was all business. I mean, there was nothing personal ever. I just, it was a business transaction that went south. And, I never wanted it to come to this, but it did. And I'm happy with the decision. So
you're living someplace better now?
Oh yeah.
Yeah.
Yeah. We have a nice big house now. So we're very happy.
For you. Or with a Harvey now?
Okay, the rules about security deposits vary from state to state, but there are many, many states that have a rule that says that the landlord has to give a letter to the tenant within 14 days of moving out if they're keeping any of the security and explaining why. And if they don't send the letter within 14 days, they could be responsible for as much as 3 times the security.